In 1963, Congress passed the Equal Pay Act, an amendment to the Fair Labor Standards Act. It attempted to abolish pay inequity based on gender. It had loopholes that allowed employers to continue paying women and minorities less than their fair share. All they had to do was give the jobs different titles. In 2017, the Oregon State Legislature passed the Pay Equity Act. It tightened up the law by considering jobs to be the same if they have comparable character. Their duties and characteristics are sufficiently similar regardless of their title. The Oregon law also defines 10 protected classes. These classes form the basis for compensation equity. An employee can have a valid claim of compensation inequity if they are paid less than others that do the same job of comparable character because of their inclusion in the 10 protected classes. If you operate within the state of Oregon and have more than one employee within your company, including yourself, you must abide by Oregon's Pay Equity Act. Here are 10 things you need to know about the Pay Equity Act. Number 10. Size doesn't matter. The Pay Equity Act impacts all businesses operating in Oregon regardless of size. Basically, if you have more than one employee, even if they are part-time, you must abide by the rules set in the Act. Number 9. Key dates. Although the law took effect in October of 2017, the teeth of the Act started January 1st, 2019. As of that date, an employee that feels they have been paid unfairly compared to others that do the same essential job can sue for damages. It is now illegal for businesses operating within Oregon to ask job candidates about their past salary history. This previously common request is now verboten. To go even further, a candidate's salary history, even if voluntarily provided by the candidate, cannot be used by the employer in their hiring decision, nor can it be factored into the compensation offer. Number 8. Continuous statute of limitations. Although the Act provides a 1-year statute of limitations for claims against an employer, that 1-year period begins anew every time the employee gets paid unfairly. Essentially, as long as an employee keeps getting paid inequitably, they get a year from that date to file a claim. Number 7. 2-year pay penalty. If an employee succeeds in their claim against their employer that they were compensated unfairly, the guilty employer must pay an award of up to 2 years of back pay plus attorney's fees and other damages. Whatever an employer hopes to save by paying an employee less than others that do the same job, it will cost them that and a whole lot more if they get caught. Number 6. The 10 protected classes. The crux of the Pay Equity Act centers around pay disparity based on the employee's status among 10 protected classes. An employee can have a valid claim if they are paid less than others that do the same job of comparable character because of their race, color, religion, gender, sexual orientation, national origin, marital status, veteran status, disability, or age. Number 5. It's more than just pay. The Pay Equity Act refers to pay, but it is actually based around compensation as a whole. Compensation is more than just wage or salary. It includes bonuses, benefits, fringe benefits or perks, and equity-based types of compensation, such as stock options. For example, if all things are equal between 2 employees that perform the same job, but one gets less vacation time than another and there is no justifiable reason for it, that employee can likely file a claim of unfair pay equity under the law. Number 4. Justifiable cause. Not all employees that do the same job must be paid the same. There are many different factors that can give an employer justification for giving their employees different compensation packages. These can include tenure, experience, performance, working conditions, and many others. The point of the law is that the difference must be justified and reasonable and not based on the 10 protected classes. Number 3. Everything must be documented. In order to understand how employees are compensated, and to understand if 2 jobs are functionally the same even when they have different position titles, employers must document and analyze not only their staff information, but the jobs themselves. This is perhaps the biggest tangible impact that pay equity has on employers. For example, let's assume a fictional employer has 2 workers named Bob and Susan. They both get paid the same wage and have exactly the same benefits packages. For sake of argument, let's also assume that they have identical performance history. After documenting their work history, the employer finds out that Bob has worked in his position for only 2 years, and Susan has worked in her position 5 years. Susan may have a valid claim of pay inequity because it took her 5 years to get paid, but it only took Bob 2 years to earn. A pay equity analysis will reveal these situations. It will give the employer the information they need to ensure they are compliant with the law. It will also give them the information they need to justify pay inequality in the case of a claim against them if the disparity is legally justified. Number 2. Protected classes are sensitive subjects. Employers are in a somewhat precarious position. They must ensure employees are not being compensated unfairly based on 10 protected classes, yet they cannot directly ask about an employee's inclusion in most of those classes. For example, an employer can determine an employee's age, but they cannot ask about that employee's religion or sexual orientation or ethnicity. It is advisable for employers to seek legal counsel that specializes in human resources and hiring matters to determine how best to engage in hiring and staff management practices to ensure they aren't attempting to comply with one law while violating another. And finally, number 1, comparable character. A key difference between the Federal Equal Pay Act of 1963 and the Pay Equity Act of Oregon is the concept of comparable character. This means that two jobs that are functionally the same but have different titles are still considered the same under the law. How does an employer determine if two different positions have the same comparable character? They must document several key aspects of the positions. The state's definition of comparable character is work that requires substantially similar knowledge, skill, effort, responsibility, and working conditions in the performance of work regardless of job description or title. A thorough inventory of every position held in the company is required to establish comparable character. This must be done on an employee-by-employee basis. For example, a manufacturer of auto parts must inventory the position characteristics for every employee on the assembly line, not just a generic assembly line worker inventory, and assume everyone that holds that position is doing the same job. Employers must gather staff details and inventory every position held within the company, then conduct a pay equity analysis on that data to identify where compensation equity exists and where it doesn't. Corrective steps must be taken when inequities are found. It is important to note that an employee with higher compensation cannot have it reduced to bring parity with their peers. In an inequitable situation, the employee or employees with lower compensation can be raised up, or those with higher compensation can have it frozen until others catch up. Compliance with the Pay Equity Act is not a one-and-done situation. A pay equity analysis is strongly suggested at least once every 3 years, but ongoing compliance by updating the staff and job inventory every time a change event occurs is the best practice. Change events include new hires, promotions or demotions, relocations, performance reviews, new benefits packages such as a different health insurance plan, raises, etc. This is one of those things that is easier and cheaper to maintain on an ongoing basis than it is to perform a heavy lift every few years. In addition, ongoing maintenance of your staff and job inventory with an automated pay equity analysis system will ensure inequality won't be occurring without your knowledge. Remember that 2 years of back pay penalty from number 7? It would be a lot cheaper to correct a situation with a week's notice than it would if you found out a year later. If you operate in Oregon, even in part, and have more than one person in your organization, you must comply with Oregon's Pay Equity Act. The most cost-effective way to do this is through Apex by eRep. Get compliant and get equitable with Apex by eRep today. Go to erep.com/employers/apex to learn more.